Welcome, class. Today we are going to discuss an aspect of copyright law, large measure of which has already been covered while discussing remedies in intellectual property law in general. So, you're all advised to watch and read the content covered in today's lecture along with the content of the earlier lecture so that information supplements your present knowledge and this information complements that. Specifically in today's lecture, we are going to look at both civil and criminal remedies. So that is clearly a difference from the earlier lecture where we had spoken only about civil remedies. And also specifically we are looking at the Copyright Act in this lecture and the different provisions contained therein and what the act has to say about both civil and criminal remedies. But before we embark on a survey of the provisions in the Copyright Act in India and the discussion of its provisions, a more elaborate understanding of what they mean, we need to kind of start with the international conventions, if not anything else, to see the nature of philosophy that drives enforcement globally. Post TRIPS, I don't think anyone would disagree that one can't ignore the international aspects of IP while interpreting Indian law. Of course, we may finally decide to deviate, but even when deviating, the informational base has to accommodate for the international conventions and what they say about any particular issue in IP. The same holds for infringement as well. So, looking at remedies for infringement in copyright, the Berne Convention never really had any elaborate remedies, and all it really did was leaving the matter of remedies under Article 5.2 to the laws of the country where protection was claimed. Articles 13 and 16 of the convention did allow for some seizure of infringing copies of a copyrighted work, but it never really had an elaborate mechanism or anything of that sort, resembling anything even close to that. But TRIPS, on the other hand, has been a different animal. TRIPS has had a fairly elaborate mechanism in Part 3 for enforcement of IPRs. Article 44 authorizes judicial authorities in member states to pass orders of injunction restraining parties from committing acts of infringement, including importation of infringing goods, such that the channels of commerce are kept free of these goods. Article 45 of TRIPS again authorizes authorities to order payment of damages adequate to compensate for the injury the right holder has suffered because of an infringement of his intellectual property right by an infringer who knew or had reasonable grounds to know that he was engaged in infringing activity. So, both the remedies of injunction and damages are envisaged in TRIPS in Part 3. When we go on to look at Section 55 of the Indian Copyright Act, we realize that the model of imposition of damages against parties who had reasonable belief of themselves involving in an infringing activity has been present in the Indian Act since 1957, way before TRIPS came into effect. So in that sense, one could even say that the Indian Act took a lot more progressive view of infringement than many of the international conventions. But before we get into that, let's quickly see the other provisions in TRIPS as well. Article 46 is an important provision because it authorizes member states to allow judicial authorities to order the destruction of infringing goods as well as materials and implements used to create them without payment of any compensation. Again, the whole idea here is that once there is an intellectual property right vested in an individual, all the property, including goods, that make use of the IPR in question are technically the property of the owner of the IPR. So when these goods are created, unless judicial authorities have the power to confiscate these goods and destroy them, the fruits of the infringement will lie in the hands of the infringer. So Article 46 specifically targets that problem and seeks to redress it by authorizing judicial authorities to destroy. Article 50 of TRIPS provides for various provisional measures, and most of it is of the kind that we have already covered in the earlier module on remedies in intellectual property law. Then we have Article 51, which also provides for border control measures, again an important provision, which authorizes member states to adopt procedures enabling a right holder to apply to the customs authorities of that state for the suspension of imports that he suspects would infringe his IPR. In this situation, all that the right holder has to do is to provide adequate evidence that there is prima facie an infringement of his intellectual property right, and of course he has to supply a sufficiently detailed description of the goods to make them readily recognizable by the customs authorities. The customs authorities can then demand security from the right owner, which is sufficient to protect the interests of the alleged infringer, and this is obviously to protect against a situation where if later it is shown that the goods were wrongfully detained, the importer can be indemnified. So this is a pretty interesting mechanism, and the Indian law again has provisions of similar effect. This is provided by way of the Customs Act and circulars under the Customs Act. Then coming to criminal remedies, again it shows the level of detailing that has gone into TRIPS, at least when it comes to the area of remedies. Because Article 61 is a pretty elaborate provision which reads as follows in respect of criminal remedies. It says, members shall provide for criminal procedures and penalties to be applied at least in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. So the attempt of the law here is to make a distinction between commercial and non-commercial violations of IPR. The provision goes on to read, remedies available shall include imprisonment and or monetary fine sufficient to provide a deterrent consistently with the level of penalties applied for crimes of a corresponding gravity. In appropriate cases, remedies available shall also include the seizure, forfeiture and destruction of the infringing goods and of any materials and implements the predominant use of which has been in the commission of the offence. Members may provide for criminal procedure and penalties to be applied in other cases of infringement of IPRs, in particular where they are committed willfully and on a commercial scale. So again there is an emphasis on commercial scale and on willful acts of infringement. And the power of the court, similar to what we had seen in Article 46 with respect to destruction of material by judicial authorities, destruction of goods. Here destruction of all the methods, materials, implements, all of which is used for the commission of the offence. There is power to seize, forfeit and destroy such materials and infringing goods as well. So these very many important ideas combine to send out the strong message that TRIPS as a treaty believes in strong enforcement, and that without strong enforcement, IP is virtually of no value. If you really need intellectual property rights to have any real value in the market, then of course you need to provide for strong enforcement measures. So with these broad ideas and brushstrokes of what the international conventions provide in respect of enforcement,